We'll start our in-depth coverage of the lease by looking at the first clause of most leases, which is the granting clause, which tells you what land it covers, what minerals it covers, etc. So, granting clause defines what rights are given. It generally imposes no obligation, so by itself, it doesn't say that the company has to drill. And you just want to look at a granting clause. You all can look at your producer's 88 example lease for the substances covered. So, it's usually going to be oil and gas and other minerals, but sometimes it will include other minerals specifically. And you want to look at the land covered. How does it describe the land that it's talking about? And the size of interest, because what we'll see, this creates a lot of complications throughout oil and gas law. But a lot of times, somebody only owns a fraction of the minerals in a property. So they might be leasing just an eighth of the mineral interest, or just a 20th, or just a 100th. So you want to look at the size of that interest included. So here's your producer's 88 granting clause. You can assume when I put sort of long excerpts up here, there might be some little abbreviations, but basically this is what it says. Note, as I said, this is typically the first clause. This is paragraph 1. The lessor, in consideration of some amount of dollars, so there'll be blanks in these form leases that can be filled in with different amount of dollars, in hand paid, of the royalties herein provided, and of the agreements of lessee herein contained, hereby grants, leases, and lets exclusively unto the lessee for the purpose of investigating, exploring, prospecting, drilling, and mining for, and producing oil and gas, and all other minerals, conducting exploration, the following described land in blank county, Texas, to wit. So you can see this basically leaves space for the amount of compensation for what the land specifically is, and it grants rights to produce oil, gas, and all other minerals. Now, when we look at that granting clause, we want to note a couple things. One, are there any special surface uses permitted? And we'll talk about what surface uses are sort of implied in an oil and gas lease. We'll want to look at what substances are covered. So, is it just hydrocarbons? Here it said oil, gas, and other minerals. Sometimes it will say sulfur as well. Sometimes it will mention other minerals. And we'll see that the term minerals is often ambiguous, and so we have to do further analysis to see whether a particular substance would be covered. What land is covered, that can be important. And we'll talk today about some of the things that you try to avoid mistakes in terms of how the land was described, including Mother Hubbard clause, and we'll look at some other examples at the very end of this lesson. So we also want to see what interests are covered, including, is there a proportionate reduction clause, which basically says, look, if you told me that you owned a quarter of the mineral interest here, and it turns out you only own an eighth, then is there a reduction in the royalties and other payments that you'll receive? Okay, let's look at surface uses. We'll do that by looking at a North Dakota case from 1979 that's on page 195 in your book. That's Hunt versus Kerbaugh. The lessee, which was Hunt, offered Kerbaugh money to explore for oil. So basically, Hunt said, we got to come on your property. Here's some money. Let us go on your property and explore. We have the right to produce oil and gas from your land. We need to do some exploration. Kerbaugh rejected that. And Kerbaugh said, look, when you've come to do exploration before, we had a spring damage, a water spring damage, debris was left. I don't want you on my land. Take your money and go away. Hunt files for injunctive relief. So Hunt's the plaintiff, and it says, look, I got to get on to operate to explore for oil and gas because I have the right to produce oil and gas here. Kerbaugh responds, look, you don't have the unlimited right to enter for your extensive exploration activities. I'm already mad about the last time you were on the property. You don't get to come on. Court says no. When you sell your mineral interest or you lease your mineral interest, that comes with an implied right to use the surface as reasonably necessary to obtain minerals. So you can't prevent the oil company from going on once you've leased the property or once you've sold your minerals. The mineral estate is dominant. The mineral owner is going to be able to come on as reasonably necessary to obtain minerals. Now we'll see that states sometimes offer, will sometimes do some things to give some compensation to landowners, but the basic rule is that the oil and gas company can come on. Now you might ask, well, wait a second, why did the oil and gas company offer money if it just had the right to go on that land? The basic answer is often an oil and gas company will offer money just to smooth things over and make the problem go away, make sure they can get on the land. But in fact, that right to go on the property is just implied with the sale of the mineral interest or the leasing of the mineral interest. Now, there are some limits on the implied easement, which are described in page 202 in your book. First of all, the use has to be reasonable. So you can't just come on and do whatever you want. It has to be a reasonable way of looking for or extracting oil. There's the Accommodation Doctrine. We'll talk about that. Basically, that means that if there is a pre-existing structure, then the oil and gas company, if possible, may have to find another way of extracting oil without damaging it. Has to be for the benefit of the mineral estate. So there's an implied easement to use the surface to extract your minerals. But that doesn't mean that you get to use the surface to extract minerals from whoever you want. So you might say, hey, I need to use the surface to store the oil that I'm extracting. And you know what? I'm going to store all the oil on this one property. Well, you don't have an implied easement to store oil from all your properties on just one person's property. That your use of this implied easement has to be for the benefit of the mineral estate where you're extracting oil. So you only can store products from the place where you're extracting it, the specific mineral estate where you're extracting it. There can also be limits in the lease. So if you don't want the company to be able to just come on and produce oil at any time, if there's particular parts of the season that are sensitive for them to go on, if you want them to pay certain kinds of compensation every time they go on, you can do that, but it has to be in your lease. Then, of course, there's also state laws, there's regulations and other ordinances that in other ways limit oil and gas companies' implied easement to go on the surface of minerals that they have a right to extract. Now, I said I'd talk more about the Accommodation Doctrine. Basically, the way this works is described on page 205 in your book, but if the mineral owner's use of land substantially interferes with the surface owner's existing use. So imagine that you have your backyard and you have a big property, but the oil and gas mineral interest owner wants to put a giant well in the middle of your backyard. Well, then you might say that substantially interferes with my existing use. And so the mineral owner must accommodate me, but if there are reasonable alternatives. So if it could drill just a little bit over outside the yard, then it would have to do that. It can't, if there's a particular place that the mineral interest owner has to drill, well, the Accommodation Doctrine doesn't help. But if the mineral interest owner has reasonable alternatives, then the Accommodation Doctrine can say, don't destroy my or substantially interfere with my existing use, go drill somewhere else. Okay, on the flip side, the Obstruction Doctrine limits the landowner. Once a surface owner has leased out or sold those minerals, they don't have the right to prevent the oil and gas owner from going on the land. And so as an example, if you've leased your land but then don't allow the oil and gas company on, that may toll the running of time under the lease. Because remember, the lease has a primary term where the oil and gas company can explore and start producing oil. And if you keep the oil and gas company off for 6 months, that may extend that primary term as a matter of equity for 6 months. That can be triggered also by denying title. So if you said, oh, the lease is invalid that you're operating under, maybe that oil and gas company won't be able to get funding for their well, et cetera. And so by denying title to that well, that may extend the lease as a matter of equity. Okay, let's look again at this Producers 88 granting clause. Again, you will notice it says, look, this says not just the right to produce oil, but it says you get to investigate, explore, prospect. So if that's implied, if there's an implied easement, one question would be, why is it specified in the lease if that's just implied in the grant of the right to produce minerals? So this question is in your book at page 211. If the grant of an oil and gas lease gives the lessee an implied right to use the surface of the land, why do most oil and gas leases still contain a detailed statement of the right given to the lessee in the granting clause? Might want to think about that one. But remember, a lot of the things that the oil and gas company does are about managing relationships with that landowner. And so it can help a lot, even though the oil and gas company automatically has an implied easement to go on the land, it can help to be able to point to and say, look, it says right in the lease that I have this right, and it also gives notice to that landowner. So that's something that is important to maintaining that good relationship with the landowner and the oil and gas company, even if it wouldn't be technically required because that right to go on the property is included in the implied easement. Two more things we have to talk about: Mother Hubbard and in-gross clauses. So remember that the granting clause, as you can see in your Producers 88 lease, includes a description of the land. Well, sometimes you describe the land wrong. So one solution is what's called a Mother Hubbard clause. Why is it called a Mother Hubbard clause? You can form your own guess. I have not been able to find any answer to this question. If you find one, let me know. I'll give you my guess after we talk about it. So here's a typical Mother Hubbard clause. This lease also covers and includes any and all lands owned or claimed by the lessor adjacent or contiguous to the land described here and above, whether the same be in said survey or surveys or in adjacent surveys, although not included within the boundaries of the land described above. All right. Why would you include this Mother Hubbard clause in a lease? Basically, it's if you describe something about the land wrong. And what the Mother Hubbard clause says is, really, we intended to give you a lease to the whole thing, everything adjacent or contiguous. So if we left out part of the property, that was a mistake. So imagine a property that was shaped something like this. And imagine that your description covered just the square portion of it. What the Mother Hubbard clause would say is, look, we obviously meant to include that little triangle section as well. We meant everything adjacent and contiguous. And the Mother Hubbard clause just covers up any inaccuracies in the description of the property. Why is it called a Mother Hubbard clause? Well, y'all can go back and look at the nursery rhyme about Mother Hubbard, but basically she goes to the cupboard, get her dog a bone, then the dog wants something else. There are a bunch of sort of mistakes that happen in terms of what people ask for and what they get that take place throughout the children's rhyme. If you have your own theory, I'd be glad to hear it. But so my theory of the Mother Hubbard clause is that the intent is you were really trying to describe the property. You didn't describe it quite right, and the Mother Hubbard clause solves that problem. Now, an in-gross clause, we'll see why this is very important in the coming classes, but basically this says For purposes of calculating rental payments, hereinafter provided for the lands covered hereby are estimated to comprise some number of acres, whether it is really more or less. The reason for this is sometimes you will have conditions in your lease that say to comply with the lease, you have to provide a payment of a certain number of dollars per acre. And there can be really severe consequences if you don't comply. Well, again, remember what happens if the acreage is described incorrectly. All of a sudden, you haven't provided the amount of payment you were supposed to because the acreage is different and you were making a per acre payment. So what an in-gross clause says is, look, if we calculated something wrong about the acreage here, let's just all agree on what the acreage basically is, and you have to pay per that number of acreage, even if it turns out that this property is a little bit bigger or smaller.